and in-camera submission of withheld communications, and to clarify the meaning of victim support communications, which I'm just going to short title that as like a motion for clarification. And then I have the state's response to the defendant's motion to require privilege log and in-camera submission, or the state's response to the motion for clarification. Then I have the subpoenas that were issued pursuant to the court's order that then Ms. Bridegan, Mr. Clifton, you filed a motion for protective order, which is part of the pleadings to, I guess, express concern on part of Ms. Bridegan related to the subpoenas. Is that everything? All right, am I missing anything? Okay. All right, so this is the way I read the papers. I believe that I need clarification from the state of Florida, because I left it open to the position of the state of Florida whether you wanted to, I guess, produce some of these things and then take it off Ms. Bridegan's production request from the defense. And so I need an answer to that, Mr. Siegel.
Your Honor, as I understood your order, you indicated that it would be too intrusive based on the present record to require the state to produce the victim support communications as well as the work product. So I did not review or see your order as being a directive to the state to produce those. Those were just simply set to the side. But the short answer to the court's question is no, those should come from Ms. Bridegan.
Okay. All right, so I believe that, so now the state's position is that you would not be producing anything that may be contained on devices of the identified state attorney and assistant state attorneys. So then I would have to go, I didn't believe that it was necessarily ripe. And so as it relates to the defendant's motion to require the privilege log and in-camera submission, Ms. Nelson, I want to know what, if the state of Florida's position is that they aren't going to produce any of those communications or the subject of the subpoena that was directed towards Ms. Bridegan, what, do you believe that that's now moot?
It is moot, Your Honor, insofar as there are no communications being withheld. If Ms. Bridegan or the state has also asserted statutory standing on her behalf, so it's not clear exactly to whom I should address this, but I'll assume it's Ms. Bridegan and Mr. Clifton. To the extent that no communications are being withheld as either work product or as victim support communications, then I do believe our motion is moot. But if anything is being withheld, we're simply asking that we have the opportunity to know what's being withheld and to be able to challenge those claims of privilege under Callaway. And that's the request. Okay. So the way that I read it, okay, I don't believe that Ms. Bridegan can assert any type of privilege. So if the state is saying we aren't going to produce it, then I don't think Ms. Bridegan can assert a privilege. That's the burden of the party. So Mr. Clifton, so then I believe now your motion for a protective order would be ripe related to Ms. Bridegan's interests.
Thank you, Your Honor. And Doug Clifton on behalf of Kirsten Bridegan. Is it all right if I take this off?
Sorry?
Is it all right if I take this off?
No.
Okay. It just seems loud.
No, it's necessary because otherwise they can't hear you.
Okay, all right.
You can clip it somewhere else, though.
Your Honor, there's two things in our motion specifically, and one that I didn't put in there, but I do want to address with the court. Number one is just, we didn't think anything in your order was demanding that Kirsten Bridegan provide anything directly to the defense.
Right.
We think everything should go to the judge. If there's anything to be provided to the judge, it goes to you first and not to them. Their subpoenas were saying, this comes to us, this goes to the judge. And so part of that is as far as their subpoenas.
So stop there. I don't know that I necessarily read it like that. Hold on.
in item A1,
Okay, I see.
yeah, to undersigned counsel, and then B3 to undersigned counsel.
Yeah, okay, so in my order, I didn't find, I believe that is call logs, if I'm not mistaken, Ms. Nelson. So I
correct.
don't need to review call logs. Like, they don't contain anything. It's just,
Well, and I guess that kind of leads into my other point, though, is we don't have the call logs. You know, and I mean, so there's, you know, to put the burden on Mrs. Bridegan to somehow download her own data, like, we don't have that capability unless we're going to go out and pay for something, and to put that burden on her was just, that's the next, kind of the next step in what we're arguing.
let me pause you for a moment. Ms. Nelson, I thought, like, okay, correct me if I'm wrong, okay? I thought in somehow in one of the pleadings, I have not read the second deposition, but I thought that Ms. Bridegan said that she had, like, in and out, you know, from her phone, like that she called the state or whatever. That's what I thought. And then those questions were asked. The defense said they didn't have the time. I thought that was part of it, no?
No, Your Honor, there were questions regarding whether communications happened. She said, yes, they have. There were questions regarding the amount. There was information that she put together for her second deposition in accordance with your order. That's been compiled. This, though, is stating, I mean, I think it was basically 4 years of call data. That's time, date, and everything else. We don't have that. That's not something that's been put together by us. That's something that would have to be done forensically and taken off the phone. And frankly, Your Honor, they should have subpoenaed the carrier 2 years ago and gotten that information, or a year ago. Now we're right on the eve of trial and they're demanding it from her. That's not the normal process of that. Every lawyer just goes out and gets it from Verizon.
Okay.
So that's on them as far as creating this bottleneck.
Well, they can only subpoena what you have. And so if you don't have it, that's the response.
We don't have it unless there is a forensic download of her phone. We don't have call log data that we can just provide.
Your Honor, if I may, a few points to make here. So first of all, we have a forensic vendor who has been court approved in Florida as being neutral, joining us by Zoom today.
Is that Mr. Green?
That's correct, Your Honor. Jake Green from Invista Forensics. Your Honor, previously Ms. Bridegan had opposed any sort of forensic vendor. We proposed this back in July. And so here we are again with delays being caused by switching positions. And so we are just trying to get the discovery to which the court has said we are entitled. This was due yesterday, according to the court's order. We still have not received it. We have proposed solutions. We've been seeking this information since February of this year, and we're still here in August seeking the same information. If we had known back in February that the information didn't exist, despite Ms. Bridegan's testimony under oath that she has not deleted any information from her cell phone, we would have gone out and sought a subpoena from her cell phone provider. However, her sworn testimony was, I have not deleted anything. All of this information is on my phone and I would not oppose somebody coming to get it. But here we are months later, still facing opposition. All we're asking, Your Honor, is we are seeking solutions. We are seeking to implement the court's order about what we believe we are entitled to and what the court has found we're entitled to. We're asking the court to order that Ms. Bridegan produce her cell phone this week to this court for Invista Forensics in order for us to get the information that has been ordered by the court. Mr. Green, please correct me if I'm wrong, but I believe Invista would be able to forensically image Ms. Bridegan's cell phone no later than Friday of this week.
Yes, ma'am. We could have somebody in Jacksonville tomorrow.
Your Honor, if I may, I mean, those are just misstatements. We weren't here in February arguing about subpoenas for phones or anything on the phone. Their first motion after this deposition in January was later and was just asking for a second deposition. So these are all misstatements. And as far as I know, this provider of theirs is actually working with them on this case. Like, that's the whole point. We're not just giving our phone to the defense so their guy can download everything and we're just all supposed to go along with that. That's beyond the scope of what's going on here. And I know that there was an in-camera review of materiality and everything, but we're still in the dark on what exactly is being looked for. They're asking for, and I'll just get into it now, every single direct message on Instagram? Is there specific individuals that they want? I mean, that could be numerous, and that's an invasion of her privacy. And they've had these Instagram, the only thing that's not public and that they can't recover themselves right now is the stories. Those stay on for 24 hours and then they're saved on
The
the
stories.
Instagram has stories.
Okay.
And that's a 24-hour thing. Her site is public. They can go through it, they can pull all the comments, they can pull everything they want off it. So I understand
But
the
Mr.
story.
Clifton, my understanding, at least from the pleadings, is that there was a point in time in which it was public. Then there was a point in time that it was pulled down at the request of the state, and then it was put public or something. Am I wrong about that? Like that, I thought I read that.
There was a time where it went down and then it's back up. I mean, it's been on for years. I went through it this morning. There's comments, there's posts, they're asking, and that's another thing I wanted clarification. They're asking for direct messages. That's private messages that she's having with anybody else. If there's not a specific person involved in that, that's an enormous amount of information. That's phishing, and that's an invasion of her privacy and harassment.
Your Honor, if I may be heard, Mr. Clifton is attempting to relitigate our original motion. This is our 6th hearing on this issue. The court has found materiality. The court has found particularization as to specific communications, which are outlined in the court's August 11th order. We're not asking for anything more than what the court has authorized, and any sort of attempt to recast what we are seeking is incorrect. And I want to correct the record and be very clear. We sent a letter to the state on February 6th.
Wait, let me interrupt you, Ms. Nelson. So I'm looking back at the order. These arguments that you're making, Mr. Clifton, I have settled them, I thought. I said no sweeping requests for all direct messages, account settings, viewing history, metadata. Instead, I said the narrow request of legal theories, statements about defense counsel, statements about guilt or innocence, instructions, that is what they would be allowed to do.
Direct messages concerning defense counsel, defense team, or defense guilt or punishment, that's basically, when you say that, it's just Justin for Jared's site. That's what it's about. It's about this trial. I think everything can be concerning guilt or punishment. And to have her go through all that and try to figure out what is what.
I don't think that she needs to self-edit. So if there are messages, and that's why I wanted the hearing. The papers have, they keep flowing and flowing and flowing, right? The initial request was centered around, there is no mystery about that. They put it in the initial pleading, which is disparaging comments about defense counsel.
Those were on a story that they have. I mean, you understand, in January, they questioned her about those specific comments, and she said, yeah, I made those.
Right. And then, so I put to bed that issue. Now they are seeking what may not be, that might have been related to that particular disparaging comment.
So is anything that Mrs. Bridegan then said and anybody else in a private message on Instagram, all that's discoverable?
No.
That's what direct messages are, though. That's what that means.
No, I would go through them in an in-camera review, and I would only disclose what would be within that parameter. I'm not asking you to self-edit.
Are we going to have an opportunity then to see what's going to be provided them and object again? Because I still don't understand what the materiality of direct messages are. That's private messages she's having with somebody, and somehow that's relevant to her testimony? I know we're in the dark on a few things because there was that in-camera materiality argument. I don't know what they provided to you, Your Honor, but I do know that going through direct messages, just private messages of hers, where does that lead? That is nothing but a fishing expedition. If you're saying we want a private message that she sent to EF or this particular person because that's material, okay, then maybe, I get that. This is just, we want every direct message for 4 years. That could be thousands. So there just needs to be a narrowing down. If there is materiality to it, that is a very broad spectrum of information that she has to hand over.
Your Honor, if I may offer a limiting principle, which I believe the court already contemplated in its order, and that is due process and to discovery under the rules. We believe the court has struck the right balance and put in place the correct procedural safeguards. We're asking this court simply to effectuate its order and to require Ms. Bridegan to comply.
So I'm going to read the order again. I said, this court grants a targeted in-camera review of Justice for Jared content consisting of posts, comments, and direct messages concerning, these are the categories: defense counsel, defense team, defendant's guilt or punishment, and then any communication about stopping, editing, deleting, and that came from the state, the initial pleading that said that the state said take it down. This court has found the materiality of it, and I understand the burden for which this places on Ms. Bridegan. I can foresee any number of ways to take it off of her. The state of Florida doesn't want to do it, and I don't think that I can order them to do it.
No, but there needs to be a neutral party that's going to do it. The defense needs to pay for it, and then we would still like the opportunity before anything goes to defense
who is
to offer
Mr. Green?
objections. He works for them.
He does not work for us, Your Honor. He has assisted with this case. Invista Forensics is an independent third-party contractor that the defense has contracted with, and as I said previously, has been found by other courts in Florida to be a neutral third party for forensic purposes. I apologize, Your Honor.
I'm sorry. Go ahead.
I'm not hearing any solutions being proposed by Ms. Bridegan, only objections. Ms. Gardner is here offering solutions. We initially offered a forensic vendor. They said no. We asked then, okay, please direct her to produce, and now they're saying no. We came to court with a forensic vendor to propose to the court. They're still saying no, but they're not offering a solution. Your Honor, what we're asking for is simply that this court order that Ms. Bridegan comply. If they want to propose a third-party vendor by noon today, we're willing to meet and confer with them. We also disagree that Invista is not qualified to do so. They're professionals, Your Honor.
Your Honor, Christina Stifler for the state. I'm not speaking on any of the issues other than Mr. Green. In just my experience, Ms. Nelson joined the case relatively late in the proceedings, but I have been in contact with Mr. Green for a number of years. He's been retained by Ms. Gardner's defense team as an expert and or consultant. He's gone through all of the discovery. He's rendered them opinions. He's participated in litigation in the disqualification proceedings. So just to give context to Mr. Clifton's argument, he is not an independent. He's a part of the defense team, has worked on defense strategy, and has had access to all the state's electronic discovery in the criminal proceeding. So, I mean, I can get with Mr. Clifton and propose perhaps seeking somebody else who has forensic capabilities to do so, whether through law enforcement agencies that are unrelated to this case or otherwise. But I just wanted to clarify that I do know Mr. Green has worked extensively on this case and has had access to state's discovery and defense strategy for years.
And Your Honor, we did provide a manner of compliance. That is our suggestions. As much as the defense would like to say it's not, but we just want a neutral provider. She can provide her phone to them. The information will go directly to you, nothing to the defense yet. And whatever happens then, we would want the opportunity to provide objections to anything that's going to be provided to them, because we're still left in the dark.
Okay.
Your Honor, we have a proposal. JSO has the capability to do this today.
As long as they're not busy.
We would propose that JSO be directed to complete the forensic.
She can't hear you. Go ahead. I'm sorry.
I apologize if somebody else was speaking. I couldn't hear.
No, it's okay. Let me hear you. Okay.
Thank you, Your Honor. We would propose that JSO complete the extraction today, and that then be produced to the defense consistent with the court's order not to the defense. The categories that were ordered produced in camera be produced in camera to the court to the extent that they haven't already been produced. They were due to be produced yesterday, and then the specific call log metadata issue, which was ordered produced directly to the defense, that be produced directly to the defense no later than Friday. I would imagine it could be done today, Your Honor, but we're willing to agree to a production date by Friday for that which is due to the defense.
I don't know. I don't know that JSO can do it. But let me ask this. All I can do is ask at this point, because this is a subpoena to a non-party. The state is taking a position of basically not facilitating. I don't know if I don't want to call over there. Maybe Ms. Nelson, you can call over there. Would Ms. Bridegan have an objection to JSO imaging the phone?
As long as any information is going to the court first, Your Honor, there's no objection to that, but then we would still want an opportunity to object to anything that's going to the defense.
Well, I ordered that the call log go. I don't know.
That's the what? Call, time, data, date, duration?
Right, like something they could have gotten from.
Should have gotten from Verizon or whomever.
Right, like the in, out. I don't know that she would have any privacy right in that, like just.
No, I agree, Your Honor. So
that goes to the defense. I've ordered that. So, but the other substantive, I have to do an in-camera review. I have to make sure that it's not impacting her privacy rights related. And maybe I was inartful, but victim support communications. I've got to. I'm sure they have. That is, the defense wants to litigate what that means, and what I mean by that is the Constitution, Marcy's law. That's what I mean. Ms. Bridegan has a constitutional right to communicate with the state of Florida. She has a constitutional right to consult. She has a constitutional right, so all of those, while not privileged, she has a constitutional right in that level of communication with the state to be informed per the law. So that's, maybe an inartful word, but, I don't know that crosses the line into what the defense has shown to be material in this case. She shouldn't. She should be and feel comfortable and confident that her constitutional rights are also guarded. So I try to strike that balance. But I do understand the calls in and out and in. I think they get it. They get it directly. But I don't know how to effectuate it because, and I want to know from you, Mr. Clifton, what is the difference between picking someone and then they get paid by the defense?
Because they won't know the defense. This is somebody who's familiar with the defense, Your Honor. I mean, we're just not comfortable at all handing over a phone to somebody who is hired, paid by the defense as an expert in their case.
Do you know someone?
But there are other forensic, there's capabilities around Jacksonville.
Do you know someone?
I could find somebody. I was hoping the court had somebody in mind.
I deal, Mr. Clifton. I deal in criminal law. The only person I see up on the witness stand is JSO.
I've never had a client have to have their phone dumped. I mean, this has never happened. So I'm in a new territory.
I have been searching any case that would give me some type of guidance. I am walking in total gray territory. I'm doing my very best. Okay, I think we're all out there somewhere.
I think the biggest concern then, I understand and they're trying to put deadlines on things. This was supposed to happen yesterday. That's their subpoena was yesterday. We ignored that and objected to it. The timelines on things, it might take a little longer than Friday to get them everything they want, or Friday for the court. And frankly, Your Honor, Mrs. Bridegan, this trial is happening right now.
I agree. And
it's just going back to the burden on her for doing all this, but I understand, and I will take the burden of hopefully trying to find somebody to do this for us. But again, and I think where you were on the right track talking about constitutional rights, the other constitutional right in Marcy's law is that she has to be heard at anything regarding her rights. And again, before anything goes to the defense, we want to know what it is and offer objections to it, because we are, again, in the dark on materiality of really specifically DMs and that kind of thing. But we'll get into all that. I mean, again, because that could be, Your Honor, that could be thousands of messages. I mean, I
have no idea.
that's called a fishing expedition. I mean,
I am also in this trial. I've got to be present and thinking, and I wanted to try to resolve this issue. I don't want to, and I understand both sides, and I am very, very cognizant of the constitutional rights of both Ms. Bridegan and the defendant. I've got to strike that balance, and I'm trying. So what I would ask, I'm not ordering, I'm ask, can the state of Florida please contact JSO and see if they would be willing to do it? If they are not, then I'm going to put it on Ms. Bridegan, unfortunately, okay? So, and then you propose a name of somebody. I don't know. That's who sits in this witness stand day in, day out. Okay, it's JSO.
well, who's going to pay for that then, Your Honor?
Your Honor, our firm has used Mulholland Investigations many times for that purpose. I don't know.
Mulholland.
Mulholland, they're local.
I know him. I actually know Mulholland.
They do that work. I've used them for downloads all the time.
Can you get me the information, please? How can someone vet it for me? Like, how, I want to know how long they believe that it would take. Can they set the parameters that the court is? I don't want her whole phone dumped. That is against the law. And there is a way, I think.
I will talk to the expert, see if there's a way to do it as it's described here, almost like a piecemeal pull.
I don't want to sell bright. First of all, I don't have the bandwidth to look through somebody's phone like that. Okay, I thought the best I could, narrow categories, and that's all I believe that should be produced. I don't want our whole phone. I don't want. That's against the law, period. Okay, so.
Let me find out then if that's the capabilities, and we can take it from there, Your Honor. But I would still say that the bill be presented to the defense and they can pay for it since they want it. Ms. Bridegan shouldn't have to pay for it.
If I may, Mr. Green is former law enforcement. He's worked on forensics, both on the state level and the federal level. He can answer the court's questions regarding capability if the court is willing.
Mr. Green, if you raise your right hand and be sworn in. What? Okay. Sir, do you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
All right. What download software do you use?
Yes, ma'am. So our office does two different download capabilities that would be used in a case like this. One through Cellbrite Premium, the other through either, if it's from law enforcement like JSO, would be through GrayKey. Our version of that is called VeriKey.
Can you spell it for the record?
Yes, ma'am. Cellbrite is CELLEBRITE. GrayKey is GRAYKEY. VeriKey is VERAKEY. I feel like I'm in a spelling bee. As you've described, you don't want a complete download of this person's phone. You want what's called an application-specific phone download. Both products, Cellbrite and VeriKey or GrayKey, have the ability to do application-specific downloads for call log, text messages, the Instagram application.
Can I ask you, hold on just a moment. Let me ask you about the Instagram application. Does that require to hook to the site, or it's whatever might be contained in the phone?
That you are correct. That is only going to be what is existent on the phone. So if that account that you all have referenced of Justice for Jared is not on that phone, we're not going to get data from it. It would have to be pulled either through a court order or search warrant to Meta, to pull all of that information, or if we still have access to one of the administrator's accounts, they can log in through a web browser and request that account be archived. That comes down in a format like a zip file that would be processed in forensic software and produced to the court with those messages, direct messages, whatever the court says is responsive. So you do have, for the call logs themselves, yes, the phone at this point is the best piece of evidence. Most likely the carriers do not keep records that long. For Meta, you have, if this account is physically on this phone or Ms. Bridegan has access to a phone that has it, yes, we can get pieces of it. But the best source of evidence for Meta, for the page, is going to be directly from Meta itself.
Okay. And with both software that you identified, is that keyword search, meaning that it would capture photographs or screenshots of those things, or would there have to be a download of photographs that are related to that?
No, ma'am. If the messages, based on my understanding, something like a text message between Ms. Bridegan and State's Attorney's Office, is that
No.
the example that we'd like to use?
So my understanding from the pleadings is that some of this, for example, that the court has already reviewed our screenshots. How would that be accomplished?
That was from Instagram.
Messages, and yeah, some of them were.
Okay. So the messages themselves can still, that same application specific download for messages, it will pull, if there was an attachment for a picture or a video or an audio message, all of those will be pulled within that database. It can then be applied with a date and time filter. It can be keyword searched. Many different ways that we can pull that data and turn it into a subset of data for you to review instead of giving you the 100,000 page Cellbrite PDF.
Okay. Thank you. Do any of the parties have any questions?
No, Your Honor. Thank you.
State of Florida, Christina Stifler. Mr. Green, if you were to send a search warrant to Meta, isn't it true that Meta does not have the ability to send back a targeted reply? When Meta receives a search warrant, they return all information for a specific Instagram account.
I don't have the ability to send a search warrant to Meta. However, if JSO or another law enforcement agency was, law enforcement can specify you do not have to ask for any and all data. You can't do keyword searches, but you can apply a date and time.
Okay, but Meta sends back everything. They don't parse out keyword searches, specific accounts, specific individuals, specific users. Whatever is in that account for that time frame, they send back.
I believe that's what I said. They do not give you a keyword responsive list. They give you can apply a date and time filter, but that's the same with the download. You're going to wind up with a subset of data that would then need to be filtered as pursuant to whatever the court allows for their review.
Your Honor, Your Honor, we object on two bases. First, the state withdrew its statutory standing as to Ms. Bridegan. They're not a party to this particular motion litigation. And secondly, this is beyond the scope of Mr. Green's knowledge. He doesn't work for Meta. There's been no foundation laid.
Judge, I'm just sitting here, and I'm by no means am I an expert, but I have had experience with Cellbrite and Meta through the course of my work as a homicide prosecutor. And we had an entire hearing, Ms. Nelson and myself, and Detective Padilla from JSO testified that third-party providers like Meta or Apple are unable to do content-based returns.
Right, but my memory of his testimony was that he would bring in the big cloud of information and he would break it down into what was actually granted by the court. That was my understanding of his testimony. That he would then only give law enforcement what was authorized by the court.
Well, he is law enforcement, but number one, there's no way from Meta to get content-based returns. And even if you request a date-specific time frame from Meta, generally, because they are a corporation and they do not want to waste time and money, they don't parse it out. They will send, as Detective Padilla testified to, they'll send back a wider date range that's even requested. I just want to clarify that. I'm not making an argument.
I don't know how we got on Meta. This subpoena is for the phone. If it's on the phone, okay. If it's not on the phone.
I want the court to understand that from my experience, and just for everyone to know, if we're looking for experts who can do this, when you do a cell bright extraction or forensic imaging of a phone, trying to do a partial extraction and parsing the data in the extraction itself leads to inaccuracies in the data that's being retrieved. The only way to get accurate data and to get the entirety of what the court is ordered and what they are specifically looking for would be to do an entire extraction of the phone and then parse it from there.
That's not lawful.
I understand, but what I'm saying is there's a practical limitation on what everybody's talking about here, which is if you are requesting someone's text messages, say between Kirsten Bridegan and Christina Stifler, they could be stored in a variety of manners in databases on a phone. And if you only go to native message application and try to pull them, you could be missing other ways in which they're stored. You could be missing metadata. They could be duplicated. They could not pull everything entirely. Instagram messages can be stored on phones under the message category within Cellbrite itself. I'm not making any kind of argument. I'm taking no standing. I'm just asking Mr. Green to clarify, because my concern is I'm hearing that we're going to recover the data being ordered by doing these content-based extractions. And from my experience and from the testimony of Detective Padilla earlier in this case's litigation, I don't think that that's going to yield accurate results.
That was Ms. Nelson's argument. That was her argument in a nutshell. She said, what's good for the goose is good for the gander. The state of Florida said they get it all, we should get it all. And then everyone shut that down. I've spent an enormous amount of time, researching, looking, and this has to be done in some type of way that the civil people do it. I don't know if they download the whole phone or what they do, but like the only guidance I kind of get, which don't address the issues that are pending before this court, are civil cases that, the judges parse this out in camera reviews. They don't have the same constitutional rights. That's exactly what Ms. Nelson argued in the very first hearing that we had, and the state of Florida shut it down. They said no, and there have been nothing but objections, and I'm doing my very best to balance all of this. And I do not want her whole phone. I don't think it's lawful. I think I've said it in a number of different ways, but I do believe, based on the information that this court has been given by the defense in this case, that I have to balance Ms. Bridegan's privacy rights against Ms. Gardner's constitutional rights to a fair trial. Discovery, regardless, in the state of Florida is liberal, and it has to lead, and this is a trial case. Therefore, that means that bias, interest, and whatever can be tested by the defense in a number of different ways. And so they have identified this. This is where I'm at, Mr. Green, I don't understand what you mean really by log on to the internet and get whatever from Meta or whatever. I don't understand any of that. The subpoena is for the phone. It has to come from the phone. I'm not expecting, nor would I order, because that's not the proper venue. There is a segment in the case law that says that, is this the proper vehicle, meaning is this a proper object, Ms. Nelson, that this information should come from. You're not going to use Ms. Bridegan's phone to get access to Meta that you could have sent a subpoena to, It's either on the phone or it's not. That's where I'm at, So I don't understand, that's not going to be ordered by this court, like logging in somewhere and getting that stuff that way. I don't think I did, but...
We
Kite,
agree, Your Honor. We're not seeking that, and we
Okay.
don't believe that the court's order authorizes that.
All right, I just want to be clear, because no, that's a no. All right.
Judge Kite, regardless of the vendor you choose, we need to ensure that there is an application-specific download of Instagram and the call logs. That is we're not asking for a full file system download. It's called an application-specific.
Application specific?
Specific, yes, ma'am.
Okay.
I've been invited to speak on this from the magnet forensics vendors, spoken at conferences on it. We can do a complete download of the phone. I believe you've already said that that is not going to happen. Application specific for things like the phone call logs and the messages and Instagram, whatever you say. There are vendors, including Invista, that have the ability to pull a isolated image of just that specific application.
And so to the extent that the state of Florida is indicating that I've been asked, okay, to narrow the categories, narrow what is recovered from Ms. Bridegan's phone, the state has objected. I've made my ruling, okay? And if it is taken out of context, it's because that is what that's been what's requested by the state. And if there is something in rebuttal that might be existing in her phone, the state of Florida doesn't want to look. And so that's what it is, okay? So, do you want to get in contact with Mulholland or?
I will, Your Honor. I'll talk to him about application specific, talk to him about what can be done in regards to this board specifically.
So I want to make sure that you are heard fully. I don't know if that clarifies. Mr. Clifton, if it's on the phone, okay, and it is substantive, meaning that there's actual information other than phone number, date, time. Like, I don't find any privacy interest in that. And it's isolated per the numbers that are not public, okay? Those numbers, if they could isolate it that way, the defense gets it initially. They don't need to know who Ms. Bridegan was calling every single day.
And that would be the, so is there a list of specific numbers that the defense has provided that we are pulling call data?
Yes. Yes.
Your Honor, I apologize. We can't hear if somebody's speaking right now.
He turned it off, sorry. Say that again.
Sorry, Ms. Nelson, I didn't want you to hear me. Obviously, pulling call data logs for 4 years is an enormous amount of information. I think you've already alluded to it. You're just going to get a bunch of calls to other people that are none of their business. If there is a specific phone number, I didn't see it.
I did not put it in
listed
there.
in the subpoena, but if there is, I mean, and that would be obviously A, B, L, B, E, F, I think Detective Johns and
The prosecutors that were identified.
yes. So if they have those phone numbers, want to provide them, yes, I will again talk to Mulholland and see about pulling that specific information if that's a possibility, and if we can avoid a full phone dump, Your Honor. And that would be,
That's what I ordered. That goes directly to them.
yes, but it's I don't know what their numbers. I mean, like
Well, I don't either.
okay.
And I wasn't going to put it in an order that was.
No. But again, I mean, but if they just need to be specific, I guess. I mean, if it's to them, the subpoena was just like, we want the call logs, and I get it, to A, B, and everything else. But I know there was a number of phone numbers that I think AB used. So
Well,
just for
I don't
clarification
have those
purposes.
numbers. So, Ms. Nelson, will you work with Mr. Clifton and get those phone number list, please?
We will, Your Honor. I will say for the record that the state of Florida knows their own phone numbers. If they could be directed to provide them to Ms. Bridegan and or the defense for production. When we attempted to ask about this in the deposition, we were asked not to ask about it because understandably so, the state of Florida did not want cell phone numbers in the transcript.
I get it. Will
we
you do
not
that,
have all
please?
the information.
Okay, so from the state's perspective, if you could give the phone numbers that are relevant, I obviously did not want to put that in an order, okay? Give them to Mr. Clifton. And
Your Honor,
then,
could
yes.
we require a production deadline for them to produce these phone numbers? Ms. Bridegan also knows the phone numbers. So our concern is It's delay after delay after delay, and we already have a missed court deadline from yesterday. So we're just asking that this information be provided in a timely fashion.
Ms. Nelson, I've got to first figure out who's going to do it before I put a deadline. To me, that's reasonable. I understand. I've got a jury back there waiting. I've got to figure. I need an answer. So if you could get back to me maybe today so that I can make a decision about timelines, please, Mr. Clifton.
Yes, Your Honor.
And is the state going to see if JSO could do it or no? JSO is not going to do it. All right.
I'm not going to ask him.
All right. I want to make sure that whatever is produced to the defense, obviously the rules of discovery still apply. So, Ms. Nelson.
Understood, Your Honor. And I just want to make clear, Your Honor, that we had requested the full image. They objected. They came back and asked for an image, and now they're objecting again to their own proposed solution. So I will also reach out to the proposed vendor. We've proposed a vendor. We will get back to the court today.
Thank you.
And to the extent that we need another status, which we hope we don't need to interrupt the court's schedule in order to effectuate the court's August 11th order. But if we do, we will certainly ask to be put back on calendar this week.
You have priority on this. I designate this as a priority case. I need to get this issue settled so that you all can be prepared for trial. Okay. So I'm not interested in any more delays, but I'm not going to put just a random deadline out there when I don't know the specifics of whether it can actually be accomplished. Okay. So with some more information, I'll try to be reasonable with both sides, understanding that we need to get moving. We need to get past this issue and settle it to the extent that we can settle it in a courtroom of law. Okay.
Thank you, Your Honor.
All right. Thank you.
Thank
All right.
you.
I'll just get, hopefully by the end of the day.
Yes, Your Honor.
Okay. Thank you. All right. This hearing's adjourned. We're going to be in recess briefly to set up for the trial.
Yeah, I'll do it. So you're gonna